There's a significant update in the fight over concealed carry laws, one that could impact states like New York, California, Hawaii, and others that continue to push restrictive gun control measures. A critical case out of Hawaii, Woolford v. Lopez, is now heading toward the Supreme Court, and it's drawing national attention. This case challenges Hawaii's sweeping restrictions on concealed carry and is currently under emergency review at the nation's highest court. The plaintiffs are asking the Supreme Court to step in early and strike down the state's ban before more damage is done to Second Amendment rights. What's especially noteworthy here is that the U.S. Department of Justice, under Attorney General Pam Bondi, has stepped in to support the challenge against Hawaii's law. That's a surprising but welcome move. Joining the DOJ are 25 pro-Second Amendment states, all urging the Supreme Court to take up the case and put a stop to these unconstitutional restrictions. The case is gaining serious momentum and is scheduled to be discussed during the Supreme Court's next term, with a conference happening in early September. This could be a turning point in the legal battle over public carry rights. At the heart of the challenge is Hawaii's response to the Supreme Court's Bruen decision. Rather than aligning with the ruling, Hawaii doubled down by enacting Act 52, a law that made the state's already tight concealed carry laws even more extreme. This statute created a default rule. Concealed carry would only be permitted on private property if the owner gave express permission. That meant you were effectively banned from carrying in most public places unless the government or property owner said otherwise. This kind of law isn't unique to Hawaii. California has enacted something similar through Senate Bill 2, and that's currently being challenged in another major case, May v. Bonta, where I'm personally a plaintiff alongside Reno May and several others. It's the same tactic. States trying to sidestep the Constitution by rebranding public and private spaces as off-limits to lawful concealed carriers. In the Hawaii case, plaintiffs pushed back. A federal district court issued a temporary restraining order, later turning it into a preliminary injunction. That judge said Hawaii's new law likely violated the Second Amendment and didn't hold up under the framework established by Bruen. But when the case reached the Ninth Circuit, things took a turn. The court reversed the injunction and sided with the state, upholding the so-called catch-all property ban. The Ninth Circuit leaned on outdated historical restrictions related to hunting and private land to justify the concealed carry ban statewide. Plaintiffs then asked for a full unbanked review by the Ninth Circuit, but that request was denied. Still, not all judges agreed with the decision. Judge Van Dyke and others sharply criticized their colleagues for allowing the Second Amendment to be treated as a second-class right. That criticism helped push this case toward emergency review at the Supreme Court. Now, it's important to understand that this case is facing an uphill battle. Historically, the Supreme Court has been reluctant to take on cases at the preliminary injunction stage. They generally avoid reviewing cases that are still in an interlocutory posture, meaning cases that haven't reached a final decision in the lower courts. In fact, most similar challenges have been denied by the court for that very reason. However, this case may be different. The recent support from the United States government and the Department of Justice has strengthened its position considerably. In a surprising but significant move, the DOJ and the Attorney General's office filed an amicus brief in favor of the challenge. That brief clearly states that Hawaii's near-total ban on concealed carry is directly at odds with the Bruen decision and the long-standing constitutional principles it reaffirmed. The brief emphasizes that Bruen confirmed the right of ordinary law-abiding citizens to carry firearms in public for self-defense. And even though this case is still at the preliminary injunction stage, the U.S. government argues that the Supreme Court should step in now. Why? Because there's essentially nothing left for the lower courts to review or develop. There's no additional evidence needed. Everything is already on the record. In fact, during proceedings at the Ninth Circuit, Hawaii itself admitted that there was nothing more for the trial court to consider. That's a key point. The state of Hawaii conceded that the factual record was complete, and no further development was required for the court to make a final ruling. This admission has now come back to haunt them. In their latest filing, Mr. Woolford and his legal team highlighted this contradiction. They pointed out that Hawaii is now trying to argue that the record is incomplete and that the case isn't ready for Supreme Court review. But that argument directly contradicts what Hawaii previously told the Ninth Circuit. During oral arguments at the Ninth Circuit, Judge Schroeder asked Hawaii's legal counsel a very direct question. What else is there left to decide? What else needs to be litigated in this case? The attorney representing Hawaii responded clearly, "We think that there isn't anything. We think at the end of the day, these are not Second Amendment violations." Woolford's attorneys are now pointing to that statement as a binding judicial admission. According to them, and rightly so, this type of admission carries serious legal weight. Once a party makes such a concession in court, they can't simply reverse their position when it becomes inconvenient. Even more importantly, the Ninth Circuit's decision relied heavily on that admission. The court used it as part of its reasoning to side with the state and reverse the injunction. So now, Hawaii is in a difficult position. They can't legitimately argue that further evidence is needed when they've already told the courts the opposite. This inconsistency is critical because it undercuts Hawaii's opposition to Supreme Court review. If there truly is nothing left to litigate, as their counsel admitted, then the highest court in the country has every reason to step in and settle the issue now. There's also been a significant debate, both in the briefs and at the lower court level, over what kind of historical context should actually guide the court's decision. Unfortunately, the Ninth Circuit leaned heavily on Hawaii's own state-specific history and tradition. Hawaii has argued that its historical restrictions on public carry, dating back to at least 1852, are enough to justify its broad ban. In essence, the state is claiming that its local tradition should override the broader national historical framework. In response, the plaintiffs have made it clear that Hawaii is mistaken in relying on its own unique historical practices. They argue that Hawaii's suggestion that its long-standing local restrictions somehow make the current law constitutional is fundamentally flawed. What the state is really doing, they argue, is trying to elevate its own local traditions above the founding-era principles of the United States. And that, according to the plaintiffs, is simply not how constitutional interpretation works. The plaintiffs emphasize that the Supreme Court's Bruen decision makes this point very clearly. Bruen stated that when courts evaluate gun laws under the Second Amendment, they must look to the nation's founding-era history and tradition, not isolated practices from individual states, especially not outliers. A state like Hawaii, with a relatively recent and unique history compared to the original colonies, cannot override the constitutional principles established in the 18th century. Moreover, the plaintiffs again highlight that Hawaii has already conceded, before the Ninth Circuit and now before the Supreme Court, that there's nothing left to develop at the lower court level. They argue that a final decision on the merits isn't necessary at this stage because the key issues have already been addressed. The record is complete, and the legal question is ready for review. The Ninth Circuit, however, failed to follow the historical framework required by Bruen. Instead of focusing on the founding-era understanding of the right to bear arms, they relied heavily on Hawaii's state-specific history. That approach is clearly at odds with what the Supreme Court outlined in Bruen, where it cautioned against placing too much weight on outliers. The court made it clear. It is the general national tradition, not scattered, isolated practices, that should guide constitutional interpretation. Despite these challenges, the case has picked up significant momentum. It is now officially set for conference on September 29th, during the early part of the next Supreme Court term. This means the justices will soon meet to consider whether to hear the case. As a reminder, it only takes 4 votes from the 9 justices to grant certiorari and move the case forward. There have been major developments here, particularly with the involvement of the U.S. government, which has strengthened the challenge. The fact that federal authorities have taken the unusual step of supporting this case at this stage shows just how serious this issue has become. We'll continue to watch closely as this progresses. Once the Supreme Court makes its decision on whether to hear the case, we'll have a much clearer picture of what comes next. If you'd like to support the channel, consider subscribing. Your support means a lot and helps us keep covering important legal battles like this one. Thanks again for watching, and stay tuned for more updates as this case unfolds.